Okay, let's be honest. There are few things that can make your heart sink faster than getting a notice from HMRC, the UK's tax authority. An investigation, it just feels like you're stepping into a huge, scary unknown. But what does it actually mean? Well, today, we're going to pull back the curtain and demystify the entire process, turning that fear and uncertainty into some clear, actionable knowledge. So, what really happens when that dreaded letter or phone call comes through? It's a question that, causes a ton of anxiety, and for very good reason. HMRC has some pretty significant powers, and the stakes, from huge financial penalties to your personal reputation, are incredibly high. And look, that stress is 100% valid. It's a tough spot to be in. But our goal here isn't to scare you, it's to prepare you. Because honestly, understanding the process, knowing the powers they have, and being crystal clear on your own rights, that is the most powerful tool in your defense. Knowledge really is power here.
So here's our game plan for today. We've broken it all down into 6 key parts. We're going to start right at the beginning, how an investigation even gets started. Then we'll peek inside what I'm calling HMRC's toolbox to see the powers they can use. After that, we hit a massive fork in the road, the choice between a civil or a criminal path. We'll dive deep into the crucial COP9 deal, clarify what you can and must do, and finally look at how these things actually get resolved.
All right, let's kick things off right at the start. An investigation doesn't just materialize out of thin air. There's always a specific trigger that gets the whole ball rolling. At its core, you can think of a tax investigation as a formal financial audit. It officially kicks off when HMRC gets in touch with you, usually by phone or in writing, telling you exactly what they want to see and requesting specific documents and records. And just so we're all on the same page, this is not a polite request. It's a legal requirement. They have the right to ask for it, and you have to provide it. So once that audit is underway, what can HMRC actually do to investigate? Well, in the more serious cases, they have a pretty formidable set of tools they can use. Understanding this toolbox is absolutely key to grasping just how serious this can be. When we're talking about criminal investigations, their powers are far-reaching. They can get search warrants, you might have heard them called dawn raids. They can use something called a production order to legally force you to hand over documents. And yes, they even have the power to arrest people. In the most serious cases, they can even use covert surveillance to gather evidence. The term dawn raid, it sounds like something out of a movie, right? And for good reason. It's an unannounced search of a property, and it's almost always done early in the morning. That timing is totally strategic. It's designed to give them the element of surprise and to stop anyone from destroying potential evidence. So, what on earth do you do if this happens? First, and I know it's easier said than done, stay calm. The first thing you do is identify the officers and get a copy of that search warrant. That piece of paper is everything. It defines exactly what they are allowed to look for and where. The very next step, send a copy to your solicitor immediately. You should also ask them to delay the search until your solicitor arrives. They might say no, but you absolutely have the right to ask. And finally, if you can, get a team together internally to just shadow the officers, making a note of everything they do to make sure they stick to the scope of that warrant. Okay, so with all those powers on the table, every investigation comes to this, a massive fork in the road. And this is probably the most critical distinction in the whole process, because the destinations of these two paths could not be more different. And the difference is just stark. On one side, you have a civil investigation. Think of this as being all about the money. The end goal is a financial settlement, to get back any unpaid tax plus interest and penalties. But on the other side, that's the criminal investigation. And here, the goal is totally different. It's not just about the money anymore. It's about prosecution and securing a criminal conviction, which could mean a prison sentence. So you might be asking, why would they ever choose the civil route if they suspect serious fraud? Well, this quote from the legal experts at Elation Law really hits the nail on the head. Simply put, it's more cost-effective. A civil settlement is a much faster, much more efficient way for HMRC to get that lost revenue back into the public purse compared to a long, expensive criminal trial. But, and this is a big but, there are some definite red lines that make a criminal investigation way more likely. Things like any link to organized crime, or if the person involved has abused a position of trust, like an accountant. And this next one is absolutely critical. Any attempt to provide false documents or deliberately hide information during a civil case. That's a huge red flag for them. So since that civil path is the one most people face, let's dig into the main tool HMRC uses to handle it. When they suspect serious fraud but they want to resolve it without a criminal trial, they turn to a very specific procedure called Code of Practice 9, or COP 9 for short. And at the very heart of COP 9 is something called the Contractual Disclosure Facility, or CDF. The easiest way to think about it is it's a deal. It's an offer on the table. You agree to give them a completely full and honest disclosure of any and all deliberate tax issues. In return, HMRC puts it in writing, contractually, that they will not pursue a criminal investigation for anything you disclose. It's your off-ramp from potential prosecution. But here's the catch. This isn't some open-ended invitation. The second you receive that offer, a clock starts ticking. A big one. You have exactly 60 days to make your decision and formally accept or reject it. And make no mistake, doing nothing is treated as a rejection. That can basically give HMRC the green light to launch a full-blown criminal investigation. The whole thing follows a very clear, structured path. It starts when you get the offer. If you accept, you have to submit an initial outline disclosure within that 60-day deadline. After that, you enter a period of total cooperation, where a much more detailed formal disclosure report is put together. And the final step? You reach a settlement, pay what's owed, and you close the case for good. Okay, so through this whole maze, it is absolutely critical that you know where you stand. It's a balance of power. You have specific rights, but you also have very clear legal obligations that you have to meet. So on one side of the coin, you have your rights. You can and frankly should appoint a professional advisor. You have the right to appeal decisions you don't agree with, and you can ask for mediation. But on the other side, you have your obligations. You must cooperate fully with the investigation, you can't conceal or destroy records, and you have to take reasonable care to make sure everything you provide is accurate. And I really want to land on this point because it's so important. Even if you have the best team of advisors money can buy, at the end of the day, the buck stops with you. You are always personally responsible for the accuracy of anything and everything given to HMRC on your behalf. All right, let's bring it home. How do these investigations actually wrap up? I mean, the goal for everyone involved is to eventually get to a final, definitive resolution. The financial hit can be huge. We're talking penalties of up to 200% of the tax that was deliberately not paid. But, and this is probably the most important but in this whole process, that number is not set in stone. The single biggest factor that can reduce that penalty is your level of cooperation. Being helpful, open, and honest can directly and dramatically lower that final bill. So there are three main ways to officially put this thing to bed. The most common is what's called a contract settlement, which is just a legally binding agreement on the final amount to be paid. If you can't reach an agreement, you can try alternative dispute resolution, or ADR, where a neutral third party comes in to help find common ground. And if all else fails, you always have the right to take your case to an independent tax tribunal, which will hear your side and make a final ruling. So we end with this question, right? We've seen the pretty extensive powers HMRC has, from those dawn raids to demanding your records, but we've also seen the structured processes, the rights you have to appeal, and the pathways to settle things civilly. It all highlights this constant tension that exists in any tax system. How do you effectively police the rules and make sure everyone pays their fair share, while also making sure the process is fair for the individual taxpayer? It's a delicate balance.